this on now? Okay. Good morning, everybody. My name is Mike Wade. I'm from Bozeman. I have the pleasure today of being the acting Chief Justice. Chief Justice McGrath and Justice Morris recused themselves in this case. Before we get started here, I'd like to introduce the other members of the court. On my far left is Justice Jim Rice. Next to him is District Judge Kurt Kruger. And to my immediate left is Justice Lori McKinnon. My far right is Justice Pat Cotter. Then Justice Beth Baker. And to my immediate right is District Judge Mike Minahan. Our counsel ready to proceed? Okay. As you all know, today we have Public Lands Access Association versus Madison County in Kennedy. It's a case involving easement and stream access. It's cause number 12-0312. With that, counsel, would you like to proceed?
May it please the court, counsel, my name is Bldg. I'm with the law firm of Bldg here in Bozeman. I'm here today on behalf of Public Lands Access Association, which I may refer to today as either PLWA or Public Lands in order to speed things along. Public Lands is a nonprofit membership volunteer organization that is dedicated to preserving Montanans' rights to access Montana's rivers and streams from public highways. Can I be heard okay on this? Sorry. Is that better? Great. On behalf of Public Lands Access and its members, I'd like to thank the court today for this opportunity to present the issues in this case, which are significantly important to Montana and its citizens alike. I have 40 minutes today to present my argument. I intend to reserve 15 of those minutes for my rebuttal and to address Mr. Kennedy's cross-appeal. Likewise, I will yield approximately 5 minutes to the state of Montana so that it may also address Mr. Kennedy's cross-appeal. This case involves the overlap of two existing public rights. The first was recognized by this court almost 30 years ago in Curran and Hildreth, and that right is the right to use Montana's rivers and streams below the ordinary high water mark. The second is the right to use Montana's public highways to access those rivers and streams. Public Lands presents 5 issues on appeal today, all of which relate to one overarching question. And that question is, may Montanans use the Seyler Lane right-of-way, which is a prescriptive right-of-way, to access the Ruby River? Before the district court trial occurred, the parties stipulated that Seyler Lane is a public prescriptive easement. Therefore, the overarching question can be answered by answering 2 subsets of questions. First, what is the width of the Seyler Lane public prescriptive easement? And second, may Montanans walk from the paved surface of Seyler Lane alongside the bridge and enter into the Ruby River for recreational purposes? I'm going to deal with the second question first, and that is the scope of public prescriptive easements. The district court held that members of the public may only use public prescriptive easements in accordance with the historical uses they made of the easement during the 5-year prescriptive period. Public Lands Access requests that this court overrule the district court on that decision and instead hold that a public prescriptive road, once established, may be used for all lawful public purposes, no different than any other public highway or county road in this state. The district court relied upon a 2000 Attorney General opinion to support its holding. In that opinion, the Montana Attorney General opined that public prescriptive roads are limited to historical uses, and that the public may not use public prescriptive roads for purposes outside those historical limitations. The case that the Attorney General relied upon was a decision by this court called State versus Portman. State versus Portman, however, did not address scopes of public prescriptive easements. It addressed width. At issue in State versus Portman was an unimproved dirt road that had been developed through use which connected West Yellowstone to the state of Idaho. It was undisputed by the parties in that case that it was in fact a public prescriptive county road. Mr. Portman had purchased some property on both sides of that road and installed a building and some corrals right on the edge of the road. The state of Montana came in and told Mr. Portman that he needed to remove his structures back to leave a 60-foot wide right-of-way for the road, based upon a Montana statute that says county roads must be 60 feet wide. Mr. Portman initially refused, but then voluntarily moved his buildings back, but only left a 24-foot wide road. The state of Montana sued, again arguing that Mr. Portman's buildings and structures had to be at least 60 feet off the center line of the road. So on appeal, the issue was the width of the right-of-way, not the scope. This court held...
Counsel, jumping into the middle of the issue here right away, I understand you're going through the cases. The issue is the scope. We have a state statute that says the extent of servitudes is, and this is 7017, I believe. The extent of servitudes, including easements, is determined by the terms of the enjoyment by which it was acquired. And our court cases, including those involving public easements, have all talked in terms of whether the proposed use fits within the original purpose of the easement. So isn't that the inquiry before us today?
Yes, Your Honor, it is the inquiry before us today. And what's at issue is we have a public use, and again, this is a stipulated public prescriptive easement. So because it's been stipulated, we already have the elements of continuous, adverse, uninterrupted use for a period of 5 years. And the question is, should the court limit the use of the public prescriptive easement to historical uses, or should it allow all public uses consistent with other public highways in the state? Now, to get to your question, in order to establish a public prescriptive easement, it is required for a party to come into court and prove sufficient use by the public, not just individual members of the public. And that includes many times use for county maintenance, public travel, trailing cattle, and those public uses are broad and wide-ranging. But of course, it's impossible to come to court and present every fathomable use that has ever been made of a public prescriptive road. Now, the precedence in this state and also outside of the state of Montana establishes that once you have a public prescriptive easement established, that it doesn't make sense then to limit it to only those uses that were presented at court, because it's the very nature of having a public easement versus a private easement.
It sounds like you're arguing that there are good reasons not to follow the statute, that there are good reasons not to limit the easement to the purposes for which it was originally created.
I don't think I'm not asking the court not to follow the statute. It's no different than we go to the Lewis Lane, which in fact was a granted county road. And we all have agreement, and it was stipulated that it was in fact a county road by a grant. And in that instance, all we have is a piece of paper where the underlying landowner said, I agree to give the state, or in this case Madison County, a county road. That piece of paper doesn't say that the road may be used for installing utilities, or trailing cattle, or walking within the right-of-way, or for emergency vehicle parking, or to pull over a combine so that someone can pass by. So yes, the statute does say that a public road is limited to the extent of its creation. But in the context of a public prescriptive easement, when the evidence presented at trial reaches the threshold of clear and convincing evidence of long-standing, established, continuous, uninterrupted public use, it defies logic, according to our position, to limit that to only those uses that were presented at the trial. Because what's going to end up happening is, let's take Seyler Lane, for example. When Seyler Lane was first created, we have an agreement at least before 1950. Madison County built the road. Sometime during its existence, US West came in and installed a telephone line in the borrow bed of the road, installed power lines to go over top, and then, so basically moving a telephone line from one side of the river to the other side of the river. Under a limited historical use concept for public prescriptive easements, it would have required a brand new lawsuit to sue in order to have that right within the right-of-way. Now let's take in the future, we're going to install fiber optic cables or some type of new technology within that same right-of-way. Is it going to require a subsequent lawsuit and a new redetermination of the public rights with respect to Seyler Lane?
Counsel, doesn't that go against the, I mean, I guess I'm having trouble distinguishing Portman from this situation, because if you extend the width of the easement in Portman, you're also extending the scope of the easement, because you previously defined it as a public easement. Is that correct? So how are we distinguishing Portman from this case? You tried to distinguish Portman. Do you understand my question?
I believe I do, Your Honor, and I'll give it my best shot. At issue in Portman was width, and Public Lands Access agrees that the width of a public right-of-way is dependent upon its historical use. So the extent of public use on the right-of-way, and that's for the width. Public Lands' contention is once the width is established and provided a litigant has established the requisite elements for a public prescriptive easement, that whatever that historical width is can then be used for all lawful public purposes. And this is the same reasoning and holdings from the Supreme Courts in Idaho and Colorado and Wyoming, all of which are cited in the briefs, that you have to look to the historical use of the road in order to set the boundaries. And you can look at all different types of evidence, which I'm hoping to address today, to establish the width. But once you establish the existence of a public prescriptive easement, and you establish how wide it is, the argument then is that Montanans should be able to use the scope of that, or the width of that easement in its entirety and for all lawful purposes. Otherwise, we're going to end up in a situation where we're going to have to come back into court every single time there's a potentially new use of the road.
Mr. Geddes, you're not then arguing for a one-size-fits-all rule for every bridge in the state of Montana. You still acknowledge that each prescriptive bridge is going to have to be determined on a fact-based or made a fact-based determination on the width of that easement.
Yes.
Council, you are saying that in public highway, you're not defining purposes beyond that. It's for the lawful purposes. Is that correct?
I'm sorry, I'm having a hard time hearing you.
You are saying that in relation to once a road has been declared a public highway, that it can be used for all lawful purposes, and you're asking it not to define more specifically than that. Is that correct?
That is correct.
And is there any other case law other than Portland that attempts to do so?
That attempts to establish width.
Or no, that attempts to establish defined use, other than what counsel or what Justice Rice has indicated in terms of statutory.
Well, I don't believe that State versus Portman addressed defined uses at all. So I'm not sure if I'm understanding your question.
Well, so we have no other case law that has defined specific use other than width. Is that correct?
That is correct, Your Honor. It is Public Lands' position, and this is actually an issue of first impression for this court, that never before has a party come in and challenged the scope of uses permitted within an existing or a litigated public prescriptive easement. And so this would be the first time that this court will have to decide what uses in Montana may Montana citizens and visitors alike make of public prescriptive easements.
Counsel, I want to follow up on this issue of width. You're focused on that. And I want to direct your attention to the new statute that was passed by the legislature in 2009, and that's 23-2-3112. And in subsection 2, it states that absent definition in an easement or deed to the contrary, the width of a bridge right-of-way is the same width as the right-of-way of the road to which the bridge is attached. And with that in mind, the district judge in this case did not define the width of the easement on Seyler Lane, did it?
It gave some definitions, yes, but it did not set it forth in a manner of measurement. So we don't have a width in feet of the right-of-way at Seyler Lake.
But it's tied to monuments on before you get to the bridge that are off the side of the road. Is that correct?
Yes.
As I recall, it's fence lines and that sort of thing.
Yes.
Given the language in the statute I just read to you, is it your position that however the district court defined the width of that easement, that that same width carries all the way across the river to the other side?
On Lewis Lane, absolutely. With respect to Seyler Lane, which is a prescriptive easement, yes, we do make that claim, but based upon the historical uses that were made there, because it is public lands' position that a public prescriptive right-of-way to establish the width must be based upon historical use. Now the question is what types of historical uses may be considered.
Well, then does this statute not come into play in this case at all?
I do believe that it does come into play. The difficulty, of course, with a public prescriptive easement is, in Seyler Lane in particular, is we have evidence in the court record that shows that the width of the road actually varies here and there based upon the natural structures that are located along the road. So public lands' position in this case is that the width of the Seyler Lane right-of-way is the extent of occupation that has been employed either by the public, the state, or Madison County in connection with the maintenance and use of the road. Well, how do you measure that? Well, we presented evidence at the district court that the state occupied beyond the paved surface in order to build the borrow pits and to build the road up so that it was an elevated road. And we actually had our expert go out and look at the ground physically to try to determine what was the extent when they built the borrow pits originally that they actually dug up, so that we know how far out Madison County went when it created this road. The thing is that that distance is sometimes 63 feet, and then it's 57, and it's 60, and it comes in and out. So I do believe that the statute applies, yes, Your Honor. However, it's difficult to measure an exact, it's 60 feet along the entire way. So we tried to focus in just right at the bridge. I hope I've answered your question.
Counsel, I'm confused. How does the statute apply to a prescriptive easement? It looks like there are several ways to create a road. Is that correct?
That's correct.
And the road, the Seyler Road, is created by prescriptive easement. There's no dispute as to that.
Correct.
Does this section of the statute cover a road created by prescriptive easement?
I believe,
Or is it a loophole?
I wouldn't call it a loophole, but I believe that the statute does apply in concept. Now, it's going to be difficult because...
But that section of the statute that was just referred to concerns the width of the bridge.
The width of the easement at the bridge, yes.
That's right. That's not a conceptual. That's width. They're trying to establish a width of 60 feet. And does that conflict with the establishment of an easement of 60 feet over a bridge that we have pursuant to a prescriptive easement?
I believe I understand the question, and this is, when we're considering width, very similar to State versus Portman, because that's the issue in State versus Portman. And so we're not arguing that there's a 60-foot easement at Seyler Bridge because of the county road 60-foot wide statute. What we're arguing is that whatever the width of the easement is leading up to on both sides of the road, that same width of easement should carry across the river for ongoing county maintenance inspection.
Based on historic use.
Based upon historical use and likewise in combination with the statute.
So you are saying the statute applies to Seyler Road?
Yes.
So, Mr. Geddes, if prior recreational use cannot be used to establish whether or not there's a prescriptive easement, what significance is it to have that testimony at the district court level of recreational use in a prescriptive easement?
Your Honor, Public Lands Access disagrees with the legal proposition that recreational use may not be considered at all. Now, but if I agree with
to establish, as I understand, that issue is not challenged today. That historical recreational use, in and of itself, can't be used to establish whether or not there's a prescriptive easement. But
I believe we have challenged that issue. That's I think the third or fourth issue that we raised on appeal, is that the district court prevented Public Lands Access, actually mid-testimony.
so that was to establish this prescriptive easement, because as I understood, they had stipulated that there was a prescriptive easement at that point in the trial. You wanted to introduce testimony of historical recreational use. Was that to determine the width?
The width
of
yes.
the easement?
Now I understand. Yes, we wanted to use the evidence of recreational use by the public to enter into the Ruby River to establish the width, not the existence, because the parties all stipulated that the road existed as a public prescriptive road. But we knew that we had to come into court and establish how wide the Seyler Lane public right-of-way is, in particular at the bridge, because that's how the public's going to get into the river.
So it's your position that there's a historical recreational use within the prescriptive easement that established that part of that prescriptive easement at that point?
Yes, Your Honor.
Counsel, following up on that, is it your position, that only the historic recreational use prior to 1985 is relevant to the inquiry?
No, that is not our position. Our position, and I understand that you're looking at the recreational use statute
right.
when you ask that question. The recreational use statute was intended to prevent parties from crossing a farmer's field to get to a river or stream. We are looking in the context of existing road law, and we have this balance between the recreational use statute and road law. And our position here is that recreational use after 1985 is admissible, likewise, obviously, evidence prior to 1985, in order to establish the width of an existing public prescriptive easement that the parties agreed was in existence at least since the 1950s. I didn't answer your question.
I think you did. And let me follow up with a couple of, I guess, kind of get to the point questions. Is it your position that if, number one, your position is that the width of Seyler Lane right-of-way easement has not yet been established by the court. Is that correct?
Well, our position is that the court established it incorrectly and has not given us a definite width.
So you want remand for purposes of determining that width?
Yes, please. A remand with consideration of the evidence that the district court either refused to consider or prevented us from presenting.
And my next question is that if the court determines a width that does not reach to the high water mark, would you agree then that persons could not depart from that width and step on private property in order to reach the high water mark?
Yes.
Thank you.
Counsel, on that point, the district court made a finding that no area down to the high water mark had actually been shown to have been maintained by the county. So is that the missing link that you would like to establish by way of recreational use to get down to the high water mark?
2 points there, Your Honor. Yes, we do want to establish the missing link through recreational use. And 2 is the district court's conclusion there ignored the certificates of survey that we've raised on appeal here, and likewise completely ignores the fact that Madison County not only built the road, but it built the bridge, and it rebuilt the bridge in 1976 on Chestnut. So the finding's incorrect.
And along that same line is your contention that Madison County has a duty to make repairs to the stream bed in relation to the bridge. Is that correct?
It must, because well, if you look in the photographs, which are in the evidence, you will see that there's actually some riprapping there, and there's a concrete abutment that holds the bridge up. If Madison County can't get into there to maintain the bridge abutment and the riprap, then they would have no means of reinforcing or maintaining this bridge in the future. So we do disagree with the district court's conclusion there. One, we think it's incorrect, and we also believe that the district court incorrectly disregarded certain evidence for unanimous opinion.
So, counsel, currently we've got a public easement between the fences that was established by the district court, and it narrows as it approaches the bridge, and that's where the public easement stops, except for the paved portion where the egress across the bridge. Is that correct?
Well, what we have is the district court's opinion is a little confusing. We have a bottleneck for the public at the bridge.
Right.
But then the district court says the county gets a maintenance easement necessary to maintain the bridge, but then...
Right, well, let me finish my question.
Okay,
so there's a county maintenance, a secondary easement that extends beyond the fence, and you're asking for a remand to establish maintenance under the bridge and extend that easement beyond the paved portion.
In the first place, reconstructed the bridge in 1976. We have cattle trailing evidence. We have the built-up portion of the bridge where it's actually sitting on the concrete abutments. We have the riprap in the water. We have the State Department of Transportation, which accesses into the river in order to conduct its biannual inspections of the bridge, along with myriads of other types of maintenance evidence. That's all the time I have for now.
I have one more question. I think it'll be quick, but I want you to reconcile 23.2.322, which is a prescriptive easement language that it cannot be acquired through recreational use of surface waters. Is it your position that by maintenance you're not invoking the provisions of this statute? In other words, by a secondary...
Oh, I see what you're saying. Our position is that by county maintenance of the bridge, they're not accessing the river for recreational purposes to make use of surface waters. They're accessing it for maintenance purposes. So that would be admissible in connection with establishing the width of the right-of-way.
But then, nevertheless, the effect would be that you're asking it to be declared public so that recreational users could access the river.
Yes. Thank you.
Council.
May it please the court, my name is Susan Swimling, and together with Tara Depew, we represent Madison County. Madison's county issue in the present case is very narrow. The district court's declaration that the public's right to travel on the paved portion of Seyler Lane across Seyler Bridge, as well as Madison County's prescriptive right to maintain the traveled way, the lateral and sub-adjacent structures for Seyler Lane and Seyler Bridge, and the areas adjacent to the travel way must stand because they are based on undisputed fact and are in accordance with Montana law. Seyler Bridge and its approaches on Seyler Lane is a county road right-of-way that was established by prescriptive use. There is no dispute that the public has the right to travel on the paved portion of the bridge and the lane, and that is the fact that the court found it has not been disputed. The district court properly ruled Madison County has a prescriptive right to lateral and sub-adjacent structure of Seyler Lane and Seyler Bridge together with additional land that is reasonable and necessary for maintenance and repair. In accordance with Guthrie v. Hardy, 2001, Montana 122, paragraph 59, this court has held that as for the specific issues of repair and maintenance, the owner of the easement not only has the right, but has the obligation and duty to repair. The district court's determination is supported by substantial, clear, and convincing evidence, which is uncontroverted, and that's what is required by Costblade versus Mateer and Warnack versus the Conan Family Trust. And therefore, Madison County wants to request that this court, in its determination, make sure that you specify that the county has, in fact, the prescriptive maintenance requirements or prescriptive maintenance obligations and rights, as well as the right to maintain the travelway on behalf of the public.
Is anyone contesting that? Sorry, is anyone challenging that?
When you read the appellant's an opening brief, there is a question as to whether, by the way that the court made the determination in their challenge to that determination, that the entire question about the validity of prescriptive easement is brought forth to this court as not being appropriately determined.
The appellants say in their reply brief that Madison County does not oppose PLWA's claim that the public may use the Seyler Lane right-of-way to access the Ruby River. Is that a correct characterization of Madison County's position?
Madison County's sole position in this case was the declaration of the public's right to travel on the road and the county's right to maintain that road structure and the bridge structure. And they have not taken any position on any of the other possible arguments in this case. Thank you.
May it please the court, my name is Peter Kaufman. I represent Jim Kennedy, who is a defendant in this action. Because we're breaking this up and I've got a cross appeal which has not been addressed yet, I wonder if I might have the indulgence to have 10 minutes at the end to deal with any rebuttal issues that come up from the Attorney General.
Counsel, I've already talked to the clerk about that. That is not our procedure, and so we're going to carry on.
Very well.
They will have rebuttal, but you have your one shot.
Thank you, Your Honor.
Well, we're most interested in your class.
Okay. Well, today I'll be addressing the two major points in our briefs. And the first one is the one you just asked about, which is at both bridges, as a straightforward matter of constitutional law, Montana cannot retroactively confiscate the private right to control who wades or floats on a privately titled non-navigable stream. It's important to note from the outset that the stipulation in this case recognizes and states that Mr. Kennedy has fee title to the bed and banks of the Ruby River as it flows across his property. The state can't do that retroactively, regardless of whether the analysis is under the federal navigability test or whether it's under this court's construction of its public trust doctrine. Either way, the state simply can't change the law to retroactively take private riparian rights that have already vested. As Mr. Geddes noted, this case is about overlapping rights of way. And the right of way that the constitutional issue raises most clearly is what I call the aquatic right of way, the right of way in the river itself. There are three steps that lead to the conclusion that the private landowner's right to exclude the public, to do what all of us do, there's a line here and that property is yours and this property is mine. That right is established in three steps. First, federal and state law prior to 1984 was clear that the public had no right to fish in a non-navigable, privately titled stream. This court so held in 1925 in Aaron against Sutherland. Second, the right to exclude the public from private property is a fundamental property right. It cannot be confiscated without due process and just compensation. It's not the sort of right that can be balanced. It's not the sort of right that can be taken minimally. If the state wants to take it minimally or balance it, it uses eminent domain. That's where the balance comes from. It doesn't come from the legislature deciding the right balance and imposing it on the private landowner for the public's benefit. The third step.
Counsel, if I may interrupt. I'd like to move to your issue in relation to the statute of limitations. The fact that this area has been legally open to recreation for over 25 years, and now you're coming in and you're making this argument. Why isn't this time barred?
We're a defendant, Your Honor. We were sued. We intervened the first time as a defendant. When they amended their complaint, they added us, we're in the complaint. We are a defendant in this action. Statute of limitations apply to bar stale actions, to bar stale litigation. But as this court has held, as the U.S. Supreme Court has held, if the action is not stale, then no matter of defense is stale even.
But the 1985 legislature enacted a detailed list of public uses, and they stated what they are. Those are what are before us today, and that was under MCA 232307, the Stream Access Bill. I'm still having a difficult time because there's been 25 years since that time period, and you're coming back and trying to define the usage and saying it's unconstitutional.
That's correct, Your Honor. As the U.S. Supreme Court said in the Palazzolo case, there is no expiration date on the takings clause. If the state acted unconstitutionally in taking the land, then that action was void. It remains void. The passage of time or title does not fix it. This court had a great opinion in 1939, which I'd like to recite because I didn't put it in my brief. It's State ex rel Borman. And it's at 94 Pacific 2nd, 201. And what the state said there is that they had a case where land had been sold in violation of the state's constitution on the sale of public lands. And 28 years later, the person who bought that land came back and asked for his money back. He said that was an unconstitutional sale. And this court said that unconstitutional actions are void, and that the passage of time does not render them okay, does not render them constitutional. The U.S. Supreme Court also in the Nolan case, Nolan against Coastal Commission, dealt with a case where you had a subsequent landowner and took with notice of the unconstitutional taking, and the court found that they had standing to go ahead and challenge that as well.
So, Counsel, you're asking us to overturn Curran and Hildreth, aren't you, and also to declare the Stream Access Bill unconstitutional?
That's correct, Your Honor.
Could you address your point 3? I wrote number 3 on my notes, but you never got to it.
That's where I got stopped? Okay, thank you, Your Honor, I appreciate that. Point 3 is that the state cannot enlarge what the public rights over private stream bed by retroactively changing the law. Right? In other words, it's the final step, which is if the rights vested, they're the right kind of rights. They're the right to exclude, which is the fundamental right, which invokes the Fifth Amendment. And you can't, the rules of property can't be changed to take away the vested right. That itself is a taking. And the cases that stand for that proposition are cases like Stop the Beach Renourishment, which is a recent U.S. Supreme Court case in which the court said it's a taking to declare that what was once an established right of property no longer exists. Justice Kennedy, in his concurrence, said it's a due process violation. He had a different theory, but it's the same result. It's unconstitutional.
Counsel, aren't you also asking us to declare a portion of the Montana Constitution unconstitutional? Article
Yes.
9, Section 2, provides in paragraph 3 that all surface, underground, flood, and atmospheric waters within the boundaries of the state are the property of the state for the use of its people. Your position, if we were to accept it, would reject that provision of the Constitution, would it not?
That provision of the Constitution has been construed by this court and the legislature to mean that surface waters mean the bed and the banks. The definition of surface water in the Stream Access Statute is the bed and the banks. And so to the extent that that constitutional provision that you've just read is construed to mean not just the molecules of water, which can be used by people when they can get to it, but that the use of the bed and the banks, that invasion of personal space, walking on somebody else's property, to use it, that construction is unconstitutional. I think that's where the line would be.
Are you referring only to a non-navigable river, or are all water courses?
Only non-navigable, Your Honor.
Okay.
Ones like this that are privately titled in someone like Mr. Kennedy.
All right. Do we have in the water, the access laws, any definitive statement as to the ownership of the stream, of the bed under the river of the non-navigable river? In other words, how we deal with easement issues on that.
On the Ruby River right here?
We can take the Ruby
Generally.
River. Do we have a definitive statement from the Supreme Court? I don't think we do, concerning these easement questions on a non-navigable river and how private property balances with that? Or do we?
There are certainly Supreme Court decisions that draw the line between what's public and what's private. The PPL Montana decision certainly decided that the state of Montana could not control use of the stream bed in a non-navigable river. Similar, the Phillips Petroleum case against Mississippi went the other way. Private landowners for 150 years have been paying taxes on land which Mississippi decided 150 years later asserted were tidal and therefore within, that were therefore what we call navigable here in the West because the tide doesn't reach this far, but it's the same analysis. And the Supreme Court said just what I'm saying here today. 150 years may have passed, but you know what? That's the state's land because it's navigable. And they allowed the state to drill for oil there instead of people who've paid taxes for 150 years, which emphasizes the point. When you're talking about the Fifth Amendment, you're talking about takings and property law, there is no expiration date.
Is there any portion of the Lewis, and really I'm looking at Lewis Lane and the bridge at this point, any portion of the 60-foot easement that is outside the high water mark of the Ruby River and is simply across? I mean, do we have a complete overlap there? Is I guess my question.
It's a 60-foot dedicated right-of-way, so it would cross the river, and there would be an intersection at the ordinary high water mark.
And that's factually in the record?
Yes, I think so.
Mr. Kaufman, let me ask you about your third point and the ownership of the bed and banks being privately owned. In 2001, Judge Lovell addressed this issue in the Madison versus Graham case and distinguished those federal cases that you rely on in your brief, primarily on the ground that no private property right is being extracted. And he said, in fact, the public has no interest at all in the private stream bed per se, but only in the publicly owned surface waters that traverse the stream bed. So in other words, given that the stream access laws relate primarily to public activities on a public way, he didn't find the private stream bed ownership to be a constitutional interest. Do you think he was wrong?
I think he was wrong. I think if you look at the United States against Kaiser Aetna case, you can see it very clearly. That court said the confiscation may result from a taking of the use of property without compensation quite as well as from the taking of the title. And that is a case in which you had private submerged bed. It was a pond. It was dredged and cut to the sea. So it began having ocean water flowing in and out of it, clearly public water. And the federal government asserted jurisdiction over that water. They also asserted that they could now permit the public to boat over those private beds. Very similar to what Curran Hildreth did. Public water, private bed. And the U.S. Supreme Court said that jurisdiction over the water was not a blanket exception to the takings clause. They said that the interest of petitioners in the now dredged marina is strikingly similar to that of owners of fast land adjacent to the navigable water. They said that just because the water was public and there was jurisdiction over it, it did not follow that the pond was also subject to a public right of access. And that is precisely what I'm proposing to this court today, is that bed ownership controls the land above. And this court has held that before. In 1925, in a case that's on all fours with this one, this court was confronted with a serial trespasser named Mr. Sutton. And, yes, Ron?
So counsel, we're not just disputing the issue of high water marks. You're saying the entire stream.
Yes, that's correct.
So it's not arguing just the high water mark.
That's correct.
So,
And
in adopting your position, then people in Montana could no longer float the Dearborn River if the landowner who owned the subsurface stream bed didn't allow them to do so, because that right would supersede the public's constitutional right to access surface waters. That would be the holding, wouldn't it?
If the Dearborn, that's certainly the holding I'm looking for on the Ruby, which is non-navigable. The Dearborn was held to be navigable by the district court in Hildreth. And this court said that that was irrelevant, whether it was navigable or not. So your exact example...
It's not just touching the stream bed that you're concerned about, it's touching the water as well.
That's right. That's the holding of U.S. against Kaiser Aetna, That was boating, it was not a wading case, and they clearly held that you can't go above it. The U.S. Supreme Court did the same thing with another public asset, air, which of course belongs to the public, not to any individual. And that was the question of an aviation easement. The public, when can the government allow the public to float on air, instead of water, but air, allow it to float right above your house? And they said, well, you may not own up to the sky anymore, the way Blackstone and Kent and all those people said, because we've got airplanes now. But clearly you own as far up as you could build a house. And they were flying planes that low over this gentleman's farm. And the U.S. Supreme Court said, you can't do that. The soil controls the airspace above. And that exact same thing holds over the fee land that Jim Kennedy owns underneath the Ruby River. He controls the right to who can use the space directly above that land.
So is the basis for your argument that it's a physical invasion, or are you looking at the Penn Central factors?
Physical invasion.
And is that the same rationale that was used in the Kaiser Aetna case?
Yes, that's right. And in Nolan, which is a pedestrian easement, and I would say to this court that it's also floating, but this is also just a pedestrian easement. It's simple. It's as simple as saying the public can walk on land that's titled in somebody's name.
Mr. Kaufman, didn't Judge Lovell distinguish the Nolan case and say that in that particular case you were given pedestrians access to private land itself? And that's not what we're talking about in the case of the Ruby River. You're talking about the intersection of essentially two public rights of way, one of which is an easement and one of which is a constitutional right to the surface waters. Nolan was distinguishable because you have pedestrians who were given access over private land to gain access to a beach. That's not the situation here.
Respectfully, I think it is the situation here. I mean, very physically, we're talking about human beings walking from the public right-of-way and walking on Jim Kennedy's land. Now, there's water there. I don't doubt that.
Beyond the stream bed and banks, or not? That was initially my question.
I'm not sure. I'm sorry. I don't quite understand. On the stream bed itself. Yeah, he's let them walk over the ordinary high water mark, down the banks, get the feet wet, and walk. And all of that land, where those boots are hitting the ground, belong to Jim Kennedy. And I don't see any distinction between that.
But all of that is within the high water mark.
Yes.
The access to the river itself is within the high water mark, or and possibly also within the prescriptive easement. And then once you are within the high water mark on either side of the banks, as you call them, you're also within what currently the public has access to.
That's right. That's what we're challenging, is that granting the public access, the public right to walk on Jim Kennedy's private land was a taking, just the way it was in Nolan, and just the way it is in, for instance, all the rails to trails cases that come out of the federal circuit. I know this court has relied on those in the past, like in Our Lady of the Rockies. All those cases. And it's really indistinguishable.
So Aaron, just on the same lines, taking aside the bridge for the moment, if they obtain access of the stream or the creek, public access point, and they walk through it, it's your contention that they can't walk through it because the stream bed is owned.
Correct. And I base that on this court's long history of upholding those sorts of property rights. In Herring against Sutherland, that's exactly what Mr. Sutherland did. He walked up from public water in the Missouri River, up the Falls Creek, and he fished. So it was clearly water that was capable of navigation. And he walked across his neighbor's land, and he was sued for trespass. And that was count 2 of the complaints brought against him. And there was a demurrer. And this court took it on the law and asked the question, is it a trespass for a member of the public to walk on a non-navigable stream that's privately titled? And the court found that it was. The court stated that the defendant trespassed also when he waded up and down Fall Creek fishing. The public has no right to fish in a non-navigable body of water, the bed of which is owned privately. Fast forward 60 years from 1925. Where are Mr. Herron's rights? Mr. Herron was able to exclude Mr. Sutherland in 1925. In 1984, assuming he was blessed to live that long, he is no longer allowed to do that. Mr. Sutherland, the same serial trespasser who he'd been able to exclude in 1925, is now able to walk up the same creek. Where did those rights go? When were they constitutionally taken? They weren't. There is no eminent domain proceeding that's ever taken it, and there is no way to take those sorts of private rights without just compensation and due process, and there was no due process. And that's why the taking basically never happened. I mean, it's void, and that's why there are no overlapping rights of way. One of your honors mentioned the missing link. I like that phrase a lot from the earlier part of the argument, turning to Seyler Lane prescriptive easement briefly. That is exactly what we're talking about here, is the missing link from the fences down to the ordinary high water mark. This isn't merely just flat land. I mean, it's up and down as well. And there is no intersection between the pavement and the ordinary high water mark. They never meet. And if you look at the survey in your papers, you'll see they really don't meet. You've got wing walls that support the bridge, and you've got dirt running into those wing walls. And then you've got a long jump into not much water off the other side of that wing wall. This is not a case of a river that's being forded and you have a smooth, level way in. Part of what was not proven by the plaintiffs, and the Judge Tucker absolutely got right, is exactly that. There's no connection. There's also they really failed on multiple grounds to prove what this court has said over and over again needs to be proved for prescription before you take somebody's land. Width is width. I mean, when you're going to prove a prescriptive easement, you've got to prove the width. And that's the point of the Corbin argument, the Corbin case.
Is your argument that the prescriptive easement should be limited to the road, the actual road portion?
We haven't appealed Judge Tucker's order, and Judge Tucker used the fences. The fences tied to the wing walls of the bridge, and he correctly held that there had been no public use in the missing link. I take great issue with the idea that Judge Tucker didn't consider the recreational use. Every witness they put forward, they were all by deposition except for one witness, and all of those witnesses, the public witnesses, the people you actually use to prove a public road, is members of the general public. All the members of the general public that they brought forward were recreationalists. And Judge Tucker spent 5 long and detailed paragraphs of his order discussing all of their testimony. In paragraph 28, excuse me, Your Honor.
I'm sorry. So is it your contention that each multiple easement must be proven for each lawful use of public use? That we have to, each easement will have to be proven for each use?
That takes me to my second point, which is what the county's doing, which I think is what you're leading towards. The county's doing is very simple. It's exercising a secondary easement. And every easement that's created carries with it, as this court recently held in the Muscle Shell Ranch case, every easement carries with it the right to maintain. It's obvious. And the great thing about the right to maintain, and I think it's particularly great for someone like the county, is it's flexible. It expands or contracts as necessary for whatever the problem is at the time. So in a normal year where all you have to do is maybe mow a little bit to keep down erosion, all you do is you mow. But you know what? Every once in a while you got to rebuild the bridge. Well, that could take a lot of space. A lot more space than plaintiff is asking for here today. If you take plaintiff's way of looking at it and you say that the county only has the rights by prescription, what they've taken, and then you write a line on a map and you say, okay, the county inspectors walked this far from the past, you can't walk any further. And this is how much we're using to build the bridge in 1975, so if we build it again and we need a bigger crane, you're stuck with those lines. That's not the way it works, and it's not the way it should work. The way it works is it's measured by reasonableness. Well, if it's measured by reasonableness, it's the reasonableness of what? The reasonableness of maintenance, because it's a maintenance easement. That's what you measure it by. There is a scope limitation on the pertinent easement. It's always for maintenance and repair. What it doesn't do is create a new primary easement, which is what plaintiff wants to do. They want to take the maintenance area and turn it into a travel area. The Mississippi Supreme Court was had an aggressive county that tried that one time. They had a county lane, they had easement areas, maintenance areas on the side, and they said, what we'd like to do? We'd like to pave over those areas. Because there's no scope limitation, just like Mr. Geddes is saying, there's no scope limitation on that area. The county's been using it for something, so they can use it for everything. That's not right.
So then how do we define the issue of anything lawful public use within a prescriptive right of way? You're saying that's too big of a term.
Well, the prescriptive right of way, as this court ruled in Portman, is the area that's actually been taken by members of the general public. And I would point the court towards the Thompson against, what's the Thompson case? McCauley versus Thompson-Nistler is a case where the court has specified that the way this works is the public, members of the general public, walk up and down a piece of land and they take a road over 5 years by doing it openly and adversely and all those good things. And then the county accepts it and it becomes a county road. But it's putting the cart before the horse to say, okay, that they walked on, in this case, about 20 feet or so. You know, the public has been using 20 feet. The county accepts it and begins to maintain it. And now suddenly the public, that's only ever taken 20 feet, has now got 30 or 40 or whatever it is. They've never said how wide it is, by the way. I mean, they've never told Judge Tucker. Judge Tucker said he was left to guess at how wide this supposed easement was. And he's right. I mean, he's never staked out a position on how wide it is.
Extend the scope of the public easements. There was no takings claim raised with respect to the Ruby River or the public's right to use the Ruby River. Now, Mr. Kennedy, 6 weeks later, dismissed voluntarily his counterclaim. However, the alleged takings defense never challenged the constitutionality of Curran and Hildreth. This was brought out by Judge Tucker at the summary judgment hearing on July 25th, 2008. And I'll point you to the transcript, pages 111 and 112. Judge Tucker asked Mr. Kennedy's counsel this question. It seems to me Mr. Kennedy is asking this court to conclude that the public is not entitled to use public waters in the way that the public thought it was entitled to, based on things like Montana Stream Access Law. Isn't that what it's asking? Mr. Kennedy's counsel answered, no, sir.
Mr. Counsel, there is a distinction between use of water in this state and the title to the stream bed and fee ownership.
Absolutely.
And I think and I wasn't obviously there during the district court proceedings, but I don't think there's a dispute that the waters belong to the citizens of the state of Montana. And it's the use of those waters that both Hildreth and Curran deal with, as well as Galt, and the statute.
Absolutely. You're absolutely correct. There is a distinction between fee title and the public's right to use. So navigability for title is federal law, navigability for use is controlled by state law, according to Curran and Hildreth. My position is that Mr. Kennedy never raised a challenge to the public's right to use the water or the river between the high water marks, meaning actually laying foot on the ground in the Ruby River, in his answer or in his counterclaim that he subsequently dismissed 6 weeks after filing it. There's no claim that supports Mr. Kennedy's appeal in the district court below.
Well, he argued that there was a taking of private property in trying to access the state waters.
He argued that there was a taking because, according to Mr. Kennedy, Public Lands Act was seeking to expand the scope of permitted uses within the existing rights-of-way, the road rights-of-way. But he never alleged...
But that's a taking. We compensate landowners for taking property pursuant to easements and county roads.
I understand where you're going. Yes, he alleged a takings claim with respect to the rights-of-way, but he did not allege a takings claim with respect to the public's right to use the Ruby River in any pleading.
And I guess I would like to add, I don't know that that's what I see the issue as a question of access and crossing private property, and that whether we actually have a decision concerning private property of a stream bed on a non-navigable river. Which brings me to my next question, which is there any dispute that the Ruby River is non-navigable?
No.
Okay.
Public Lands' position is that Mr. Kennedy's attacks on Curran and Hildreth and almost 30 years of settled expectations shouldn't even be considered by this court because it was not raised below. And Mr. Kennedy's attempt to amend his answer and assert a new counterclaim at the appellate level is improper, totally inappropriate. The court should reject Mr. Kennedy's attack on Curran and stream access law. I do want to point out that there was some talk of the dredging case from Hawaii. Mr. Kennedy never dredged out the Ruby River is not applicable here. The question is whether the Ruby River is navigable for use. And under Curran and Hildreth, it absolutely is, if the court is going to take that issue on at all. I do want to go back to, really quickly, the district court's determination that the easement ends at the fences flies in the face of Exhibit 101 at the trial court level, in which Mr. Kennedy actually requested an encroachment permit from the county to install his fences across the right-of-way. So if truly Mr. Kennedy believed that the easement ended at the fences, why did he ask for permission to install the fences across the existing county road right-of-way at Seyler Lane? With that, I'm going to defer the remainder of my time to the state of Montana, which gives them a very short, brief opportunity to address the court. Thank you very much. May it please the court. My name is Matt Kokenauer. I represent the state of Montana in response to Kennedy's constitutional challenge to stream access law. This was a case about roads, bridges, and fences. It wasn't about a constitutional challenge to the recreational use statutes. It wasn't about the public's use of the river. It was about roads, bridges, and fences. And while I think this court could decide this case on substantive grounds, we would urge this court to hold that it's procedurally barred under 3 different bars. The first is that there's a new theory being presented on appeal, as Mr. Geddes pointed out. The second is that his claim is time barred. And the third is that when Kennedy purchased his property, he purchased it subject to Montana law, which had already decided this issue. Now, regarding my first point, in the summary judgment briefs, Kennedy didn't argue that the stream access law was unconstitutional. He didn't challenge this court's decisions, and he didn't challenge the public's right to use the river. He, on the contrary, said that the public could obtain constitutional lawful access under the Fishing Access Enhancement Program. Mr. Geddes talked about the hearing. I won't go into that, but I will talk about Judge Lovell's order that Justice Baker brought up.
Can you answer one question first? When was the state given notice of a constitutional challenge to the statute?
The state was given notice of the constitutional challenge on appeal. There's nothing in the record that there was no notice of constitutional filed by the district court. Regarding Judge Lovell's order, in the district court, Mr. Kennedy didn't argue that Judge Lovell got it wrong. He distinguished that case, and he said that in contrast to that decision, he said the landowners had challenged the constitutionality of the public's right to make recreational use of a stream under the stream access law. He then said, that public right is not at issue here. And when you tell the district court judge that something's not at issue, and then that becomes the centerpiece of your appellate argument, that's a new argument. And we shouldn't be upending 30 years of law for something the district court didn't get a chance to work on. And I think the best evidence that this challenge wasn't presented below is the district court order itself. Judge Tucker didn't rule one way or another on the constitutionality of the stream access law, and it's quite simple why. It wasn't before the judge. The second procedural bar at issue is the statute of limitations. Kennedy tries to avoid this by saying, well, it's an affirmative defense, statute of limitations don't apply. Look at the answer. There's no affirmative defense that says that the stream access law is unconstitutional. There's no challenge to Curran and Hildreth. So what is this if it's not a backdoor attempt to challenge this and to raise a takings? It's a claim that's barred and it shouldn't be considered.
It's barred procedurally for failing to raise, not because of the time statute.
That's correct, but I think that, I don't know what this is. Because it wasn't raised, it's here for the first time. The other bar that's at issue is that when Kennedy started buying property in Montana, this had been decided. This court had already ruled that the stream access law was constitutional and was not a taking. So we're not dealing with an issue where there's some unconstitutional rule that's being wrapped into Montana's background principles. This court had already upheld that. And I think it's really important to remember that the remedy for that isn't to wait 20 years and try again. The remedy is to seek further review from the United States Supreme Court. And they could have done.
His argument on that point is that it doesn't apply because he's not asking for compensation.
Well, that's correct. And I think that we can all recognize that there's no need to ask for compensation. I mean, if the Ruby River becomes the only riverbed that no one can get to in Montana, there's been a huge windfall here. My point about going to the U.S. Supreme Court for review is that settled the issue. When they didn't take it up, that was the end of it. And that's what Judge Lovell found, and that's correct. And for the last 30 years, the public has enjoyed the streams and rivers. Tourism and fishing have become part of the economy. It's a part of life here. And to turn it over based on something that wasn't raised, something that's barred, would be the wrong way to go. This case was over when Kennedy bought his property, and it needs to be over now. Thank you.
Thank you to all counsel. That concludes oral argument in this case. The court will now take the case under advisement and hopefully have a decision out within the next couple of months. And thank you all for coming today. This is a great example of our democracy in this state in action. So thank you all very much. Thank you, counsel.